Hi, Assalamualaikum, and a very good evening to Madam Zara. Okay, so my name is Nur Raihan binti Abdul Wahab, and my matric card number is 30-19F1021. Today, I would like to present about business law. There are 5 topics, and I'm gonna present 4 of them, which is law of contract, legal aspects of business entities, law of agency, and sale of goods. Okay, we start with law of contract. So, law of contract is an agreement enforceable by a law that is legally binding between the parties. In Malaysia, the governing legislation is Contract Act 1950. So this is the act. First of all, I choose the basic elements of a valid contract. There are 8 of there are 10 of them. I choose 7 of them, which is intention to create legal relation, certainty, legal capacity, consideration, offer, acceptance. So we start with acceptance. Acceptance is when the party accept the offer from offerer, which is the acceptance can be made in word, expressed, or by other than word implied. So the section related is section 2B. You can refer it to the Contracts Act 1950, and I will explain it. What is this section? So in section 2, in this act, the following words and expressions are used in the following senses unless a contrary intention appears from the context. The section is section 2B. When the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. So, okay. Next, we go on to offer. Offer means one party make the offer, another party accepts the offer, and the both party achieve. So it is related on section 2A. When one person signifies to another his willingness to do or induce offer. There are no related section in this part, so I will go on to the next one. Next one is intention to create legal relation. The parties must have intended their agreement to have legal consequences. The law will not concern itself with purely domestic or social arguments. So intention to create legal relation, there are no section related. So we go on to the next one, which is certainty. The terms and conditions must be clear in meaning. When the terms are vague, it is difficult for the courts to construe what in actual fact was agreed by the parties and what are the obligations and duties arising from such terms. So this part is related on section 30. Section 30. Agreements void for uncertainty. Agreements, the meaning of which is not certain or capable of being made certain, are void. So then we go on to the next one, which is legal capacity. Parties entering contract must competent or have legal capacity to contract. So it is related on section 11, section 10, and section 12, limited company, private company, public company. So the effects of incorporation is separate legal entity, can own property, can incur its own liability, limited liability, can sue and be sued, methods of receiving income, perpetual succession. So we move on to the next topic, which is law of agency. Law of agency is the relationship which subsists between the principal and the agent who has been authorized to act for him or to represent him in dealing with others. So first one, we pick agency by formation. First one is express appointment. The principal appoints the agent expressly, either orally or in writing. It is based on section 140. An authority is said to be expressed when it is given by words spoken or written. So next one is implied appointment. It is under section 140 also, but it is an authority is said to be implied when it is to be inferred from A, the circumstances of the case, the things spoken or written, or the ordinary course of dealing may be accounted circumstances of the case. So next one is ratification. How it may happen. There are two situations, which is when an agent has exceeded his given authority. Another one is when a person who has no authority has acted as if he has the authority to act on behalf of the principal. It is based on section 149. So the section 149, where acts are done by one person on behalf of another but without his knowledge or authority, he may elect to ratify or to disown the acts. If he ratifies them, the same effects will follow as if they had been performed by his authority. So next one, we would go to necessity. A person who has no authority may become an agent due to the necessity of or emergency circumstance in order to protect the principal from any loss. It is under section 142. Let's check it. So an agent has authority in an emergency to do all such acts for the purpose of protecting his principal from loss as would be done by a person of ordinary prudence in his own case under similar circumstances. So next one is estoppel. When the principal himself induces the third party to believe that a person, not an agent, has authority to act for him as if that person is his agent. This it is under section 190. So when an agent has, without authority, done acts or incurred obligations to third persons on behalf of his principal, the principal is bound by those acts or obligations if he has by his words or conduct induced such third persons to believe that those acts are and obligations were within the scope of the agent's authority. So next one is duties of agent towards principal. First one is to obey the principal's instructions unless they are unlawful act according to the custom. So it is under section 164. Due care and diligence in carrying out his work. It is under section 165. Keep proper account when required, which is section 166. To pay to principal all sums received, which is section 171. To communicate with the principal with all reasonable diligence. It is under section 107. So the last one is duties of principal towards agent. Pay agent commission and other remuneration agreed upon unless the agency relationship is gratuitous. To indemnify and reimburse the agent for anything done in carrying out these duties. Another one is not to prevent agent to earn commission. So we move on to the last topic, which is sale of goods. First one is what is sale of goods? It is under section 4(1) of Sale of Goods Act. A contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a price. So we move on to the implied condition. There are 6 of them. First one is title. If a person sold the property of others without permission, he is considered as not having the title of the property. In a contract of sale, there is an implied condition as on the part of the seller that in the case of a sale, he has a right to sell the goods. We move on to the next one, which is description. It is a common practice where you must describe the goods that you want to buy to the seller. If the seller does not sell you the goods as you described, he is in a breach of condition as to description under section 15. So next one is implied condition as to time. If a buyer fails to pay by an agreed date, it does not automatically entitle to the seller to repudiate the contract except there is an express term stating so. This contract is under section 11. So next one is implied condition as to fitness for purpose. For this condition, the buyer must mention his purpose of buying the goods. If not, he cannot claim breach of implied condition as to fitness against the seller. It is under section 16. Implied condition, there are merchantable quality. Merchantable quality means the goods is not broken or damaged and can be used. It is also have sufficient quality to be purchased at the requested price by a reasonable buyer. It is under section 16(1)(b). Next one is implied condition to the sample. If Elka wanted to buy cookies from the seller, the cookies must be similar with the sample of cookies that Elka has tasted before the purchase. It is under section 17(1). So next one, we move on to exceptions to the rule, which is estoppel. The buyer obtains a good title in the case where the owner by his conduct makes it appear to the buyer that the person who sells the goods has authority to do so, and the buyer relies on that conduct. By that, the owner is stopped by his conduct from denying the seller's authority to sell. It is under section 27. So we move on to the last one. Remedies for unpaid seller. Rise of lien. Section 46(1). Only applicable to the unpaid seller who is still in possession of the goods. The seller in this case is entitled to retain possession until payment or tender of the price by the buyer. Okay, that's all. I have explained all of the topics. So that's all for now. Okay. Bye.